I'm Philip Behrendt, Chair of the BHBA Taxation Law Section. The tax section is sponsored by Hochman Sorg Torshap Perez PC. So Hochman Sorg Torshap Perez PC advantage is experience, an eye for innovation, and genuine dedication to clients, their families, and their business. In addition to their national practice in civil tax and criminal tax controversy and related litigation in federal and state courts, the firm is also active and successful in handling other non-tax white-collar investigation and prosecutions. I'm delighted to introduce our speakers today, Ciro Immordino and Katherine Lien, and our moderator is Michelle Weiss. Michelle is a principal at Holz, Slavitt, Drabkin, and Warner. She has over 20 years of experience in tax controversy and litigation matters. Michelle helps their tax, civil, their civil and criminal tax matters. She represents her clients in all aspects of tax controversy in examination, appeals, and collection matters at the administrative level in litigation with federal, state, and local tax authorities, including the IRS, FTB, the CDTFA, EDD, and the Office of Tax Appeals. Among many achievements, Michelle has been the chair of the BHBA tax sections before me, so I'm very excited to have her here as a moderator. Ciro is an attorney and CPA who serves as the director of the Franchise Tax Board Settlement Bureau. Before moving to the Settlement Bureau, Ciro worked in the General Tax Bureau for a little over 9 years, handling like-kind exchanges, abusive tax avoidance transactions, accounting methods, partnership issues, and others. Before joining, Ciro worked at a Big Four accounting firm in the tax department of one of the nation's largest private commercial construction companies, at an international law firm in Tokyo, Japan, and at a tax law firm based in Sacramento. Ciro has taught accounting and taxation courses at the undergrad and graduate level. Katie is tax counsel at the CDTFA, the California Department of Tax and Fee Administration. She holds a master's degree in dispute resolution from the Pepperdine Strauss Institute and practiced commercial litigation and bankruptcy for 9 years before joining the CDTFA, formerly known as the Board of Equalization, in 2012. After beginning her tenure in the Appeals Bureau, she transitioned to the Settlement Bureau in 2013, where she continued her practice outside of work. She is a devoted mother of two, enjoys tax law, snowboarding, watching Netflix and HBO series. And now, Michelle, let's get started.
Okay, all right. So, hi everybody. Nice to see you here. First of all, I want to thank Ciro and Katie for giving their time to help educate all of us tax practitioners about the settlement bureaus of their agencies. And what we're going to discuss today is the scope of what they can do. We'll also mention what they can't do. And they'll provide practical tips and insights because as a practitioner, you always want to know, okay, what should I be doing? My video is very weird, and if it continues, I might have to turn my video off. But anyway, that said, just as a housekeeping matter, if you have any questions, please, let's see. Oh, there's no Q&A function here. I guess you have to, is there a Q&A function? No,
Yes.
I guess, yes, there's a Q&A function. So please put your questions in the Q&A function. We're not really going to use the slides today. They're just materials and some talking points for us. And please ask questions because this is meant to be a dialogue or, between three people about the various settlement. So I guess we can kick off. There actually is statutory authority for these settlement administrations, settlement bureaus. And I guess we could start with Ciro. You can talk a little bit about the scope and the authority of what it is you guys can do at the FTB in settlement. And then Katie can talk about the CDTFA and we'll keep going back and forth.
Yeah, hi. Well, you're welcome, everyone. I want to echo Michelle's comments about if you have any questions, please post them. It's a lot more fun when it's interactive and we can respond to your questions as we go through this. So the FTB's authority for settlements is in Revenue Taxation Code section 19442. And this was initially enacted in 1992, and it was made permanent in 1994. And what our statute gives us authority is to settle any protest, appeal, or claim for refund. And so the big takeaway there is that if you have an audit, it is premature for the settlement process. It has to be in one of those 3 steps. We have authority to settle tax disputes based on the costs and risks of litigation, which means we can't consider any other factors except for the costs and the risk. And so things like ability to pay, unfortunately, those are outside of what can be analyzed in the settlement program. And that's kind of a high overview of our authority and scope.
And Katie, do you want to speak to the CDTFA scope? And my video is being weird again.
Yeah, sure, Michelle. So we're a lot like the FTB. We also have statutory authority to settle pending appeals cases. So ours is mostly in Revenue and Taxation Code, Section 7093.5. That's for sales and use tax. But we also deal with a variety of other special tax and fee cases. So there are similar enabling statutes in those other types of tax and fees. For example, we also settle cannabis related issues. And a lot like the FTB, our authority to settle is limited to pending administrative appeals cases. So it's good timely appeal, an administrative protest, or a claim for refund. So if you're still in the audit process and there's no determination issued yet, then it is premature for settlement.
Okay, and the question, and I apologize, my video is off because it's acting weird, but for each of you, is there a time when it's too late to approach settlement?
So sorry.
Yeah, sure.
Okay, so as long as we do administrative settlements. And so, of course, once you're at the superior court, then you're beyond the administrative level. And so then any settlements happen with the AG, and we are, of course, are there to support the process as a client. But during the administrative process, all the way through an appeal with the OTA, up until there's oral arguments, then you can ask to come into the settlement program.
Okay.
Once a matter goes final at the administrative level, so whether it's you didn't protest or you got a final decision from the OTA, but once it's final, we lose our authority, our statutory authority to settle, because again, it's based on an active protest, appeal, or claim for refund.
And Katie, what about with the CDTFA?
Yeah, same here. It's got to be in the administrative process and not in state court litigation. I think, Ciro, it sounds to me like you guys take them up to the OTA hearing. For us, we do ask that they request settlement at least 5 days before the OTA hearing, because then that gives us enough time to notify everybody to stop the hearing. So we do ask that, it's at least 5 days before the OTA hearing.
So that means also when you're in front of the OTA, you still can request settlement, and that will pause the OTA process, right?
Right.
Yeah, mostly. We do, if it's a repeat request, we may not take it in, but it depends. If there's a likelihood of settlement, then yes, we do accept it, and that'll pause the OTA process.
All right, and Katie, can you just explain, how do you get into settlement with the CDTFA? Do you write a letter? Is there a form? How does that work? And what should a taxpayer include with what they send you?
Yeah, that's a really good question. It's really easy to get into settlement. You can, there's a form 393, so you can fill that out and email it to us at settlement@cdtfa.ca.gov. Or a lot of times the taxpayers will mention it during the appeals conference, and then that gets routed over to us as a settlement request. They could do it online through their online portals. But pretty much, any contact, if they indicate their interest in settlement, that gets routed to us, will be processed as a settlement request. And I think there's another part to your question, Michelle. Was it what's helpful to include in their request?
Yeah. What should someone include if they were to request settlement?
Yeah, I think it's always helpful to include their contentions. what their contentions, if they have any additional information or evidence they would like us to consider, that's always helpful to include and, to organize their arguments.
And what happens if they're including materials that were not previously reviewed by the CDTFA examiner?
We consider that too. We review that too. Although I think if it's really good information, it might be helpful to give it to the examiner or the auditor to see if they can provide a complete adjustment as opposed to, a settlement.
All right, but does it have to go through any kind of process, or is there any requirement that it be looked at by the examiner first?
No, there isn't. Yeah.
All right. And Ciro, on the FTB side, how does someone get into settlement, and what would you like to see included with the package?
Yeah, so we have FTB notice 2020-03, and that includes the process for applying for settlement. Nowadays, most people apply via email. There's an email option, a hard mail option, physical mail, and there is a facsimile option. The email, of course, is instantaneous, it's easiest. We've made our system so that once you send your email to our specific request settlement email address, you'll get a response if it goes through, which acknowledges that it's been received. And that way you have peace of mind that you know that your email went through. And so that's the process. We have access to the file. And so what we like to see in the settlement request is help us understand the risks and tell us what the parties' risks are, and you can tell us both sides, what's FTB's risk, what's the taxpayer's risk, and what we're trying to do is we're trying to tee up a good discussion, and so that's kind of like the first step in the process. And I guess to piggyback on what Katie and Michelle are talking about a moment ago, yeah, there's a difference between the FTB and the CDTFA process, where for the FTB, we like to have all the facts in the record before it comes into settlement. And if we're going through the negotiation process and something comes up and there's like a one pager or some simple document which is relevant, it's got some small impact, then of course we're going to be flexible and have you share it with us. But there's two reasons why we like to have it in the record before you apply for settlement. One is, we're 20 people and we cover all the areas of FTB. And so we'd like to understand what the FTB's litigating position is. So have the subject matter experts look at it, have them share what their litigating position is, and have that go back and forth with the taxpayer so we can go right to having real good discussions about the risks. And the other part is something that Katie touched on, which is, if you present facts which show that you're right, we don't want to settle. We want to have a withdrawal. And so if it's going to result in a partial or a full withdrawal, let's have that happen and then let's settle what's left over. So that's really important.
So the other question though is, with the settlement, what if a taxpayer thinks, I'm really correct, I am 100%, I am fully correct, but the taxpayer doesn't want to risk, for example, going before the OTA, or the cost of going before the OTA will be heavier, for example, than going to settlement, because you might have to bring in witnesses and all kinds of other things that you need to do in the hearing process and briefing and so on. And so can a taxpayer come to settlement and just say, look, I think I have 100%, or do they have to concede something?
I think for us, a settlement is a settlement, and 100% is not really a settlement. So I think there's certainly going to be concessions on both sides if it's a settlement.
Okay. And before you, so I know with Ciro, I know the answer to this question is sometimes you might put a taxpayer through a certain process in the settlement request to make sure that it's worthy of going through settlement. But do you also do that? In other words, like, Ciro, maybe you want to explain to some degree how you might get involved with settlement requests coming in?
Yeah, so I know later in this presentation, we're going to talk about, things to look at, but when someone applies to enter the settlement program, the first kind of steps, there's some due diligence and administrative steps, but at some point it gets to me to make a decision on whether to accept the case into the program. And one of the things I'm really looking for is, are we going to tee up a productive negotiation, or is there something which needs to be worked out first so that we can have good discussions? And so what happens sometimes, I see a case applies for settlement, and I'll talk to the rep and I'll tell the rep, hey, I see you're making this basis argument, but you haven't offered any evidence to support your basis. Is there evidence you have that you want to put into the record first? And sometimes rep will say, yes, I do. And so we'll have them not come into settlement. Then they'll go back to the regular part of FTB. They'll admit their evidence. They'll work up their case. Maybe FTB allows part of the basis. And then what's left over, now that comes into settlement. And so that's a lot of what I do, is to try and tee up a case for a successful negotiation.
And Katie, do you have something similar in the CDA2? And it's informal what Ciro is talking about, but do you guys go through that kind of a process also?
Yeah, not really. So a lot of times cases come into settlement very early on in the appeals process before they really develop the case during the appeals process. So we do take it in that stage too. So we don't require that they, admit it into record or anything. But if I do see, because a lot of times ours are audit cases, so they might not have any documentation during the audit, but then they later locate a bunch of documentation. So if I see that they have very good information now that they didn't have before, I might tell them, hey, I think you'll do better if you present this out in the appeals, present it to the auditor and not, try to settle it and then leave it up to them. But I've also straight up told them that, hey, I think you might fare better if you present this in the appeals process.
All right, so that, I guess, is there anything else that either one of you want to add about just the point of, trying to get into the settlement process or kicking off the settlement process, and before we get into what happens during the process? Any other? No. Okay. All right, great. So the next thing we're going to talk about is the settlement process in each bureau and what to expect. And this is in your materials. But what can you, okay, Katie, let's start with you. Can you just give general timeframes and the levels, the steps that it goes through, and how someone gets assigned to it, and all the different things that happen during the settlement negotiations and process?
Yeah, sure. And I think we put in the materials, we do have like a general table, like a time frame on our website, just a very general what to expect when you submit your settlement request. But generally the request comes in, it'll get assigned to a settlement officer the following month. If it's an audit case, we try to assign it to an auditor. If it's a legal case, it gets assigned to an attorney. So you'll expect to hear from your assigned settlement officer within roughly 2 months of you submitting the request.
Just a question. So what's the difference between those? You said there's two different cases sometimes. Can you explain a little bit more what you mean about when it goes to an auditor versus when it goes to legal?
Yeah, sure. We have a lot of audit cases. So it could be an audit of a liquor store, a car dealership, a restaurant. So if it's a audit issue, pure audit issue, a lot of times those get assigned to an auditor. And we have a team of right now, I think we have roughly 14 auditors, and they're very experienced. A lot of them were audit reviewers from the field offices. So the auditors will review the case for audit risks, and they'll work up the case. But if it's a legal issue, for example, if they're arguing nexus or some kind of exemption or partial exemption, then those get assigned to an attorney to research those legal issues.
And what about on the FTB side, Ciro?
Yeah, and so this is a good contrast between our two processes, and just reflects that we've got different taxes that we administer. And with the FTB, again, we don't have auditors in settlement who audit cases, and we don't, have attorneys who are going to be, spend a lot of time researching the issues. Instead, that needs to happen outside of settlement. And so the case gets developed, and then we have attorneys who are subject matter experts in the areas, and they're going to get up to speed on the issues and start working on the risk. But based on our volume of cases, we just don't have the resources to research issues in our bureau. And so again, we ask that cases come in fully developed. And just stepping back a little bit, I know for especially a lot of federal practitioners, one of the big differences between how the FTB and the CDTFA administer their settlement programs is, I know when you go through the feds, you're generally dealing with, in a lot of other states too, you're dealing with the same person who's arguing your case and who's also working on the settlement. But the way that we do it is our settlement bureau, it's a separate part of FTB. And so when you want to go and negotiate a settlement, you leave the part of FTB you're with, you go into the settlement bureau, and all we do is we negotiate cases. We're independent of the issue. We haven't worked on the case, previously. And, we put a lot of focus in being independent and being skeptical of the FTB's position and the taxpayer's position, trying to really take an objective viewpoint of the risks of both sides. And so I just wanted to, kind of share that difference about how our process works than some other processes that some of your participants may have been through.
Right. So for example, if you're in front of the OTA and you're dealing with an FTB attorney, and there goes my video again, 1 second. And you're dealing with the FTB attorney, that person is just litigating that case in front of the OTA, and they don't even have the authority to settle it. They have to come to you for but in both agencies.
Yeah, same with us also. Yeah, we're in a separate bureau, and a lot of times taxpayers are confused because they don't realize we're separate, and settlement is confidential. So whatever they share with us, we don't share with the appeals conference holder or whatnot. So
right.
Yeah,
So
that's a big
right.
part, is that once you come into settlement, we sign a non-disclosure agreement, and effectively our practices go beyond the terms of the non-disclosure agreement, because our goal is that we're going to come into settlement and we're going to be very open about the strengths and weaknesses of both sides' positions, including FTB's, positions. And so in order to have those real productive conversations, there's got to be a level of comfort in having those open discussions. That's how we kind of bridge the gap and get to a number in the middle, and so that non-disclosure agreement is what kind of protects all that. But again, we go beyond, our actual practices go beyond what is required by the NDA.
Which means that, and that's a really good point, because, for example, in the IRS side, after you go through appeals, if you then go on to deal with an attorney, they get the appeals file, but no one else at the FTB is going to get the file from your settlement discussions, right? So
yes,
the only thing they'll know is, oh, it wasn't successful, so now they're back, in front of the appeals officer or whatever. They're back in their OTA hearing or whatever level they're at.
Yeah, we take steps like, we don't let settlement staff on departmental teams for subject matter areas and things, and the way that we actually interact, we really understand that, we're all in the same office. And so for taxpayers to be comfortable to have those open discussions, they have to have a belief that when, we talk about these cases, that those conversations don't leave the room or don't leave the bureau.
Yeah, and I think that's a really good point for practitioners to think about, because you can really have a lot of comfort. I mean, you might say things that might not help your settlement negotiations, but you don't have to worry that you're going to say something maybe just for purposes of settlement, and then the attorney's going to somehow get it in the case file or something. So that's a very helpful point. And then, is there any other points that you want to discuss about what happens during the settlement process, what people can expect, and back and forth and all that kind of thing? In terms of like what happens? Okay, so you're now in front of settlement, and so what's happening now? You've submitted your package, and so now what can the practitioner expect next? I guess, Katie, you can start with that.
Yeah, so I do want to kind of piggyback on to what we were just talking about. I do think it's really helpful when both sides come in being very frank with each other and very open and honest, because I think when you do recognize that the other side has good arguments, I think that's when you can really work together to come to, a resolution, right? So I think it's helpful to have those open discussions. And for us, in terms of what to expect, it's always nice when the practitioner comes in organized and has their thoughts and contentions, in place for us so that we can have that, that really productive discussion instead of just throwing in the kitchen sink and asking us to figure it out. So it's always nice to, come in with your kind of your ducks in line and have your case prepared. That way we can really work towards a resolution. But if we are able to reach a settlement, then we send out our agreements through DocuSign. Once we get the taxpayer signature, then we start the formal settlement approval process. So for us, they do have to be approved by our management. And if it's over a certain dollar threshold, it goes to the Attorney General's office also, and then gets approved by our director.
And okay, and Ciro, what about on your side?
Yeah, so when a case comes into settlement, it gets assigned to a settlement officer, and they're going to go and take an initial view of the case. And they're going to kind of, they'll then meet with me, and they'll meet with some colleagues in settlement too, maybe, and we'll kind of get an initial calibration of our thoughts of the case. But it's really just an initial, and it's made to help, tee up the negotiations. One of the things that we really stress is that we're just trying to get our ducks in a row, and that the negotiations have to be open so they can be, that whatever way they flow can take hold. One of my favorite results of a settlement negotiations is when the settlement officer comes back to me and says, hey, the taxpayer kind of blew me away. They brought up stuff we hadn't talked about. And, I think the risk is totally different from kind of stuff we initially thought about. Because that's our goal, is that we want to have a real settlement conference where real discussions take place, and they're meaningful discussions, and they're merit-based. And so our goal is to really have a collaborative process to reach what everyone feels is a fair deal. And another thing about settlement, I think, which for us is important, is I think it's a healing process. I think that with tax disputes, no one likes them. No one likes going through that process. And settlement's a time when, you can be told, hey, I see where you're coming from. There's a lot of merit to what you're saying. You could win based on your arguments. And I think it's got kind of a whole nother layer to it. I think it's really meaningful too.
And
Yeah, I'm really glad you. Oh, sorry, Michelle. I'm really glad you said that, Shiro, because that does resonate with me a lot. And a lot of times taxpayers don't like the audit process, and it's very stressful for them. So sometimes settlement is the first place they understand what happened during the audit or understand how the audit was done. So yeah, I think it's a healing process for both sides.
right. And what about payment? Like how does that work? So when you get into a settlement and there's a proposal of, and obviously this doesn't work with a refund claim, it would only be when there's a deficiency of some sort. Do you have to pay up front? Do you get a payment plan? Like how does a taxpayer deal with that? Katie, you can start on that one.
Yeah, we do offer payment plans. It's a lot of times it's based on need, but currently we offer payment plans anywhere between 6 months to 30 months, and that's without financial review.
And what if a taxpayer really can't afford to pay? What happens there?
When they can't afford to pay, we have a separate unit that deals with ability to pay issue. It's the offer and compromise unit. So I think for us, they do need to be able to fund a settlement that we can get approved.
Okay, so what if someone just even the amount that if they need to do an offer in compromise, would they still be doing it based on the settlement, or would they now be out of settlement and now because they can't even afford to pay the settlement, are they now like how does the offer in compromise come into it? Are they now out of settlement at this point?
Yeah, we usually refer them to the offer and compromise unit.
So they can just resolve it based on collections anyway, right? And then, Ciro, how does the FTB operate in terms of payments?
Yeah. So first off, just like the CDTFA, the standards for the offer and compromise unit and settlement unit, they're completely different. And so there's no kind of value in trying to go from one to the other. Just the way the law works, it just wouldn't work that way. And so if you qualify for offer and compromise, then you can go there. But settlement is based on an amount due based on the risk and cost of litigation. So we don't have payment plans in FTB settlement. Instead, the amount is due at the time we have a tentative settlement. Once we receive payment, then we move the case through the approval process. That being said, we try and work with people. If people need a little bit of extra time, we try and be reasonable. The goal is to be flexible to get the deal done. And so we try and work together. If someone, is just far away from having the liquidity to pay the settlement amount, sometimes the case leaves settlement and they go back to the place in FTB they were beforehand, or they go to the OTA and they, once they have the money, then they're welcome to contact me and say, hey, we got the money, we're ready to move forward, and we'll go calculate the amount due. We'll confirm that no case law or anything has come out which changes the analysis, but assuming the risk analysis is about the same, then we'll calculate the amount due and have them pay and bring them right back in.
Okay, we have a question. Here, I think I understand this one. Also, the person who asked the question about, I'm not sure I understand it, about community property. If you can clarify your question, we can ask it. Okay, so here's one. Does settlement always start with an audit? For example, if a fiduciary paid a tax and a court later determines the fiduciary had no authority to be the fiduciary or pay the tax, is settlement a place to go to reconcile the difference, or does it have to start with filing a claim for refund? I think both of you can answer that question.
So again, under the statute, we only have authority to settle a protest, appeal, or claim for refund. And so if one of those three isn't in play, then we wouldn't statutorily be able to bring the case into the settlement program.
And Katie, what about on your side?
Yeah, I'm not sure if I understand the question. This sounds to me more like an income tax question. But I think there was another part where it doesn't always stem from an audit. No, not necessarily. It could be like a overpayment where they file a claim for refund for CDTFA settlements.
Okay, and there's another question for Ciro. Did you say payment is required on reaching tentative settlement but before final approval? What if final approval does not happen? I guess AKA your money back. Or is it now get applied to the liability or other things like that?
That's right. And so a clause in our settlement agreement states that if final approval does not happen, then you'll get the money, sent back to you.
Okay, it doesn't get automatically applied anywhere.
No, we don't do that. In fact, what we do is a settlement payment is treated as a deposit, and like any other deposit, you have the right to ask for it back.
Okay, that's helpful to know because other taxing authorities don't necessarily have that.
Yeah, and by the way, we've had times when the payment was somehow misplaced by FTB as a payment, and we unwound it and said, hey, this was a deposit, it was part of a settlement, and so we make sure that that's the treatment that it gets.
So is the taxpayer making an electronic deposit, or are they mailing you I guess if they mail you a check, you can hold it, but I don't know if they can pay by check. I don't know how that works.
So we don't hold checks. So almost all payments are electronic. And, anyone who is thinking about making a check payment, you have to be very wary because we have an e-pay requirement for many taxpayers. And there's e-pay penalty. And so those penalties are very hard to abate. And so if someone is thinking about making an electronic payment, it's better to check first and see if you have an e-pay requirement or if your client has an e-pay requirement. So we're happy to help you with that.
Okay, and well, with Katie, I guess you don't have that issue because you don't have to pay ahead of time. So it's what happens, Katie, if someone enters into an installment agreement for their settlement and defaults on that installment agreement?
Yeah,
Are
it
they
happens because
are they back to ground zero, or what happens?
yes, under the settlement agreement, there is a provision that allows us to unwind the agreement if there's a substantial non-compliance. So, if there's some kind of bad faith where they enter into an agreement and make one payment and then default on the rest of it, then, perhaps there's a substantial non-compliance where we can unwind it and revert their liability to the original amount. But I think, most of the time, as long as they've made a good faith effort to pay, it does, get monitored by a compliance staff. And then, whatever happens after that, they can work with the compliance staff to adjust the payment or it becomes a collections issue.
Okay, but so they get to try to hang on to their settlement as much as possible.
Mhm. Yeah, they actually get the benefit of it right when it's approved. So, for example, if their liability is $100, but we settle for 80, when it's approved, we basically adjust their liability in the system down to 80. And then once they paid that 80, then the liability is done. So they actually get the benefit of the settlement right when it's approved.
Okay, and here's another question. This is for the FTB. Is there a template for FTB settlement that shows the terms of the agreement minus the specific facts of a particular case? Is it available for distribution? Oh, I guess somebody's wondering if it's possible to get a sanitized settlement agreement.
Unfortunately, we don't have sanitized settlement agreements. If it's helpful, the terms are fairly simple regarding the facts. Is we agree on a number. That's a big part about settlement, is that we don't agree on different issues or any kind of weighing of who's wrong or who's right. We just agree that a tax liability is being settled in consideration for a certain number, either a payment from FTB to taxpayer or payment from taxpayer to FTB.
Okay, and I think this question was already answered, but I'll ask it anyway, just for clarification. Is it necessary or beneficial to go to settlement process even if the taxpayer needs to go to the offer and compromise unit due to the failing financial conditions at the outset? And I think you both answered that, but either one of you can answer it if you want. Okay, Ciro, answer it.
Okay. Okay. Yeah. If in this case it makes sense just to go straight to the offer and compromise.
Right, yeah, because you're gonna end up with a lesser amount anyway, so you just save a lot of resources on not having to go through the whole process, right? Okay, so are there any other things, any tips? Oh, here's a question that I have. So sometimes, and this happens, for example, with the IRS, like they're sort of different appeals officers have different styles, right? This is the thing I could give the most analogy to for settlement, where I call it like the one and done, where you send in all your stuff, they come to a conclusion, you have a meeting, and all they're doing is telling you what they think, and you're not really going to be able to negotiate anything. And other appeals officers, it's the beginning of a conversation. And so the question is, which style is used in your particular agency? So I guess, Katie, why don't you tell us? People do that
In terms of
like, is it one and done where you give everything in and then they tell you what you think, or are you engaging in a dialogue?
Yeah, I like to think we're engaging in a dialogue. Although sometimes I think if it's an audit case, the risks to us are fairly limited and the burden's on the taxpayer to provide evidence to show that they're entitled to adjustment. So, I think we do generally try to hear them out and to see what information they have that we can consider to justify a better offer for them. So it is a bit of a back and forth. But I think we are pretty upfront in terms of what we can offer and get approved based on their case.
And Ciro?
Yeah, I think, we're very similar. There's a number of different styles of negotiations, of course. And I don't know, the last like 30 years or so, what's become very popular to read books like, Getting to Yes and all these kind of modern negotiation books. You hear merit-based negotiation, principled negotiation, interest-based. And what it means is you don't have people going back and forth going, 20, 80, 60, 40, doing that type of thing. Instead, what it is you talk about the objective facts and you try and have some kind of objective basis. Like in our settlements, we're often talking about, hey, what's a court or the Office of Tax Appeals likely to do with this case? Well, let's look at other cases. How's it been treated? How are these facts different? We try and have these real productive, discussions. And so that's our general kind of approach. But talking about styles, our folks in settlement, all we do is we negotiate. We don't do anything else. And so we spent a lot of training on creating kind of these environments which lead to productive negotiations. It means that, sometimes we have someone who's upset and they've gone through a process and they're reasonably upset. And so, our folks are trained to kind of, work with them and kind of let the emotions get out and build the bridges and then, be able to get to productive discussions and, let people be heard and let them know that, we see the merit in what they're saying. And so I would say our folks are really good at accommodating their styles for the situation they are in.
Okay. All right. Well, that's great to know. All right. And I think we went over this, but when a taxpayer should choose settlement. Okay, we already discussed that. I'm just going through our list of issues. And so this is something also important, is what issues may or may not go into settlement. So what can be considered and what can't be considered. So Ciro, why don't you kick us off with that one?
Okay. And again, a lot of what we're talking about is in the PowerPoint handout or the materials that we prepared. So first settlement, number one, when the Settlement Bureau was created in 92, it was created by the legislature to raise revenue. And, one of the things that as the director I've pushed in is that our purpose has changed. And our purpose is not to raise revenue. It's to give taxpayers the opportunity to settle their bona fide tax disputes. And that's kind of what drives us. And it's important because that changes your mentality in the cases you let in, the cases you analyze, in the kind of all parts of the process. And so for us, if there's a bona fide tax dispute, we want to give taxpayers the opportunity to enter into settlement negotiations. And so that's kind of the starting point. But the issues that, generally the good issues that come in, when there's an issue of law, the law is not clear, when there's disagreement on the facts or how they're applied to the law, those are always really good cases to come into settlement. Some of the cases that are not good candidates for settlement are, does something violate the Constitution, whether the U.S. or the California Constitution, or is a reg not valid? In those cases, we usually feel that the interests of the tax community in California is better served by getting an answer to whether a statute or regulation violates the Constitution or is not valid than settling these cases. And so usually we will not accept those cases into the settlement bureau so that we can give tax community an answer on them. Again, I mentioned it before, but undeveloped cases, we want cases that are ready to have discussions. That's important. For a multi-state or, cases, we call them multi-state FTB, but for apportioning companies, sometimes there's alternative apportionment requests under 25137 of the Revenue Taxation Code. And so we ask that those go to the FTB's 25137 committee for a determination before someone has to come into the settlement bureau on those. And that way, again, we can understand what's the FTB's position on this apportionment request and what's the taxpayer's position. And then finally, the last thing I would bring up is if a case is at the end of the protest process, then the taxpayers need to go to appeal before they ask to come into the settlement bureau. And the reason for this is that, the FTB has, we've been instructed to move cases through the administrative process. And so we have to kind of weigh the needs here. And in these instances, it's been determined that moving the case through the process, and having them go to appeal first is really important to make sure that cases keep moving. And so if you're in that situation, what a lot of taxpayers do is they contact the Office of Tax Appeals and they tell them they plan to apply to the settlement program, and they can file a skeletal opening brief with the right to cure it if the case doesn't settle. So it kind of makes it as easy as process and as less work, as necessary for that case to be able to come into the settlement program.
And Katie, what about for the CDTFA?
Yeah, I think we're very similar to the FTB. There are some minor differences. I think Ciro touched upon it. We do consider constitutional arguments. For example, nexus is one that we have been seeing a lot. But I think for the most part, constitutional arguments are so broad that, we may or may not assign a lot of litigation risk to that. And I think one other minor difference is, we do consider administrative cost savings. So we like it when it comes to us early, before the Appeals Bureau has done a lot of work on the case or before an appeals decision has been issued, which then makes it hard for us to take a position that's contradictory to what the appeals conference holder has held. So, we do like to get them in early if possible, because it does, there is, administrative cost savings for the agency.
So,
can I add something? I'm really happy Katie said what she said, because there's sometimes confusion with our discussion about constitutional issues not coming in. So for us, whether something violates the Commerce Clause, those are the type of things that we oftentimes won't bring into settlement. But a lot of the multi-state cases are, by their nature, they're constitutional law. And so I don't want to have people think that a case which really is a candidate might not be a candidate. So if you have any questions, you're always welcome, or any uncertainty, you're welcome to contact me. I'll be happy to talk with you. But when I say constitutional issues, I mean things like violating the Constitution or the Commerce Clause and things like that, not the regular types of issues you see in multi-state cases.
okay.
Thank you.
All right. And we have a question. How frequently does the California AG approve or not approve a settlement agreed to by the state agency and the taxpayer? So how about Ciro, why don't you start that?
So since I've been director, I know my predecessor, I've never heard of it happening. I know. So, we do a very good job of justifying our settlements. And so, yeah, I've never seen it happen.
Katie?
Yeah, I haven't seen it happen either, but I know they are reviewing it carefully and for reasonableness, because we have gotten questions here and there from them. So we know they are looking at them carefully.
Okay. And is there any sort of hierarchy in the relevant settlement bureaus? In other words, let's say someone is negotiating with a settlement officer and they feel like the settlement officer is not hearing them and they don't agree with it, can you appeal your settlement to someone or speak to a manager, or is there some process for that? Katie?
Yeah, the assigned settlement officer should be the main contact person because if the case settles, they're also the ones that are submitting the approval package and justifying the reduction. So I think it is important to have a good relationship with the assigned settlement officer. But I understand there's going to be personality differences and maybe you're just not seeing the same issues, in which case sometimes they do get elevated. We have review teams. So, if it does get elevated, a lot of times it's the settlement officer's reviewer that then comes in and participates in that discussion to make sure there are no issues that we're missing.
And Ciro, what about in your bureau?
Yeah, we're a very flat bureau, purposefully. And so I would agree with Kate that the first step is to talk to the settlement officer. We put a lot of focus on our objective and just negotiations just in themselves are just a unique kind of subject matter. And so I think our folks are really good about when someone says, hey, I really don't think you're getting it this one. Can we take a step back and kind of explain why I think the risk analysis is off? And I think our team is really good about being open to that. I'm involved in every single settlement. And so, whatever you're talking about with the settlement officer, it's always, I'm in the loop in some way. But, if you feel that you're hitting a wall that, that you need to have some recourse, you're always welcome to contact me, and I'll be happy to listen to you. And so we focus really kind of strongly on the fact that we don't let our pride get in the way of trying to get the right result. That's why we're doing this. Is I know this has a huge impact on people's lives or tax liability, and our goal is really to get the right result. And so you're always welcome to share a concern.
Okay. And see, Katie, do you have any other comments on that issue?
Yeah, Chiro, do they get a better offer if they go to you?
What I think happens is probably if they would have gone to the settlement officer and had the same discussion, they would have gotten the same thing. Sometimes someone comes to me and I'll happily interject and kind of just be a facilitator, for that conversation. But again, a lot of what I do in my job is I try and create that culture where we get rid of the ego. We don't stick to our guns and get, kind of healed in. Instead, my job is to create that culture where we're able to say, hey, wait a second, maybe I got it wrong. Yeah, okay, where you come from? Let me step back. Let me kind of clear the brain and
Yeah.
be open to it.
And if someone has a question about the settlement process, can they reach out directly to either one of you to discuss it, maybe even before they send in a settlement? And how would they go about doing that? Katie, what about that?
Yeah, absolutely. I'm happy to provide my email address, and I think my contact information might be on the website, but the telephone number listed is my direct extension, so more than welcome to shoot me an email or give me a call, and I'll, do my best to answer your questions.
And Ciro?
Yeah, same thing. My phone number, my email, and I would encourage it too, to have a settlement request go through the process, make its way for me just to figure out there's an issue. That's a month or two of time plus all the preparation time for the representative to get that filed. And so if you have any questions, any uncertainty, that's why we're here. Reach out, please.
All right. And do either one of you have, as we're down to our last few minutes, just like a final, Kate, do you want Katie just maybe like a final wrap up on settlement and how people can proceed and any other tips or insights that we haven't discussed so far?
Yeah, I think we're all working within our our procedures and, you know, our constraints. So it's always helpful when the practitioners are professional. I think getting very aggressive is counterproductive to reaching an agreement. So I think it's always helpful to have just a very open and frank discussion of our cases together.
And Ciro?
You know, I, I would say communication is really key. You know, if any part of your settlement process or any issues, you know, please just be open with us, and we want to help you. We want to get to the right number, want to get a fair number. If there's issues, you know, to tell us about them, and let's see how we can work with you to, you know, to get a deal that works.
Okay, all right. I don't see any more questions. This question, I'm going to read it out. I'm not sure if I understand what they're asking, but maybe either one of you would understand it. And I think this is directed at the CDTFA. For a settlement, what information do you need from a California husband held personally responsible by CDTFA, something is personal responsibility sales tax, from his wife referring to community property assets? I'm not sure if I understand this question, but if it, maybe Katie, you want to just look at it in the Q&A and see if,
Yeah, let me see if I can,
understand.
what information do you need from a California husband, from his wife, referring to? Yeah, I'm not sure if I quite understand the question either. But if you don't mind reaching out to me, and you know, I might just have a couple of questions, like what is the case about? What is it? Then, you know, maybe I could do a better job of answering your question.
Okay. All right. So I guess we don't have any more questions and we're down to our last couple minutes. So I want to thank you guys again for doing this webinar, for trying to educate the practitioners who work with the CDTFA and the FTB, and for being so available and such a great resource on the issue of settlement. So thank you very much.
Thank you for having us.
Thanks for having us. Thanks, everyone.
All right. Bye.